Good morning, everybody. Welcome to the House Judiciary Committee. Madam Clerk, please call the roll.
Chair Breen.
Present.
Representatives Edwards.
Present.
Carter.
Present.
Hope.
Here.
Arbit.
Present.
Devendorf.
Present.
Hoskins.
Here.
Cerniglu.
Here.
Fink.
Here.
Wenzel.
Here.
Wozniak. Outman.
Here.
Johnson.
Here.
Madam Chair, you have 12 members present. You do have a quorum.
Thank you, Madam Chair. So today, folks, we are going to be voting out House Bills 4416 through 4419, as well as 4523 and 4525 through 4525. We're going to be taking testimony on Senate Bills 56 and 236. The first package that we're going to take up have to do with the treatment court bills. We already voted out the family treatment court. We have substitutes prepared for a few of these bills. These are to address some of the concerns from a few of the involved parties and stakeholders. And I have made a commitment to the other stakeholders that we are going to keep working towards a resolution to bring everybody together. But I think overall we've got a really great package that is going to do a lot of good for a lot of people. So we have already taken testimony on these, and let's see here for 4416. I also have some cards. I have Becky Beckler from the Probate and Estate Planning section of the bar supporting the bill, not wishing to speak. And that is it. Okay. So we are going to take up now House Bill 4416 and report it out with recommendation. Madam Clerk, please call the vote. Oh, I'm sorry. I'm going to take a motion from Representative Edwards to vote out House Bill 4416. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. House Bill 4416 is reported with recommendation.
Thank you. We are now going to take up House Bill 4417. We had testimony on this. However, we do have a H1 sub for this bill. I will take a motion from Representative Carter to adopt the H1 sub for House Bill 4417. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. I will now take a motion from Representative Hope to report House Bill 4417 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. House Bill 4417 is reported with recommendation as substitute H1.
Thank you. We are now going to take up House Bill 4418, and I would like to take a motion from Representative Arbit to report that with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. House Bill 4418 is reported with recommendation.
Thank you. We have a substitute for House Bill 4419. I will take a motion from Representative Devendorf to adopt the H1 sub for 4419. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. I will now take a motion from Representative Hoskins to report HB 4419 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. House Bill 4419 is reported with recommendation as substitute H1.
Thank you. We are now going to move on to, I'm going to briefly make a statement about some of the bills that we're going to vote on next. We have, after talking with certain stakeholders on the treatment court bills, we have some substitutes specifically for 2 different bills. That would be 4523, which is Representative Hope's, as well as 4525, which is Representative Filler's. These are going to ensure that people who are charged with or have a past conviction of murder or criminal sexual conduct 1 will not be eligible for consideration for treatment court. There's been a lot of discussion as to who else may or may not be eligible if they have some criminal sexual conduct charges, and I'm happy to say there's been a lot of progress, some healthy discussion, and we are going to keep working towards to see if we can get to a total agreement with all the stakeholders. But I want to thank MatCap for all the work that they have done. You guys have been an incredible resource, and the treatment courts are absolutely essential to our justice system. They have done so much good, and I'm looking forward to the additional good work that's going to come as a result of this package. With that, we also have some additional cards. I have Samantha Gibson not wishing to speak on behalf of the Michigan Association of Counties supporting the package. 4523 and 4525. We have Nathan Triplett representing the State Bar of Michigan, supporting the bill 4523, 4524, 4525, not wishing to speak. Judge Harvey Hoffman from the Michigan Association of Treatment Court Professionals, supporting the bills 4523, 4524, 4525, not wishing to speak. Stephanie Johnson from the Mental Health Association of Michigan, supporting House Bills 4523 through 4525. And also Brendan Lanyon, supporting House Bills 4523 through 4525 on behalf of the Prosecuting Attorneys Association of Michigan. With that, we have an H1 sub for 4523. I will take a motion from Representative Sergilou to adopt that sub. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Yes.
Wenzel.
Yes.
Wozniak. Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. The substitute is adopted.
I will now take a motion from Representative Hope to report House Bill 4523 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak. Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 4 pass. House Bill 4523 is reported with recommendation as substitute H1.
Thank you. I will now take a motion from Representative Edwards to report House Bill 4524 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel,
Pass.
Wozniak, Outman,
Pass.
Johnson.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 4 pass. House Bill 4524 is reported with recommendation.
Thank you. We now have a substitute for House Bill 4525. I will take a motion from Representative Carter to adopt the substitute. Madam Clerk, please call the vote.
Chair Green,
Aye.
Representatives Edwards,
Yes.
Carter,
Yes.
Hope,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Hoskins,
Yes.
Cerniglu,
Yes.
Fink,
Yes.
Wenzel,
Yes.
Wozniak, Outman,
Yes.
Johnson.
Yes.
Madam Chair, you have 12 yeas, 0 nays, 0 pass. The substitute is adopted.
Thank you. I will now take a motion from Representative Arbit to report HB 4525 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Green,
Aye.
Representatives Edwards,
Yes.
Carter,
Yes.
Hope,
Yes.
Arbit,
Yes.
Devendorf,
Yes.
Hoskins,
Yes.
Cerniglu,
Yes.
Fink,
Pass.
Wenzel,
Pass.
Wozniak, Outman,
Pass.
Johnson.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 4 pass. House Bill 4525 is reported with recommendation as substitute H1.
Thank you, everybody. We are now going to move on to take testimony on Senate Bill 56 from Senator Chang, who I know she is walking over right now. The committee is going to go at ease. We are back, and we have some of our esteemed colleagues from the Senate to testify in some of their bills. I'd like to welcome Senator Chang. And it looks like, are you Mr. Hunt? Welcome. Come and tell us about your bill, please.
Well, thank you very much, Madam Chair and committee members. Appreciate the opportunity to be before you today. So today we are talking about Senate Bill 56. This is a very simple bill that removes part of the penal code which forbids an unmarried man and woman from cohabitating. So this antiquated prohibition dates back to 1931 and carries a misdemeanor penalty of $1,000 or up to a year in prison, but it hasn't been enforced for an undetermined but very long period of time. The first time I introduced this legislation back in 2015, Michigan was one of 3 states to still have this law on the books. 8 years later, we are one of only 2, Mississippi being the other. But catching Michigan up with the rest of the country regarding cohabitation wasn't our only goal. This issue was brought to me by a friend and tax professional in our area because it has real tax implications for couples who choose to live together for whatever reason. The IRS Tax Code Section 152F3 states that an individual shall not be treated as a member of the taxpayer's household if at any time during the taxable year of the taxpayer's relationship between such individual and the taxpayer is in violation of local law. Because of Michigan's lewd and lascivious cohabitation provision in law, cohabitating couples are not only violating the law, but they cannot qualify as a dependent. Modifying this law will reduce taxpayer burden and place unmarried Michigan taxpayers on equal footing with taxpayers in almost every other state. This bill is not new, and in fact, in 2016, the Senate Judiciary Committee unanimously passed Senator Bita's bill. A few weeks ago, this bill did pass the Senate with bipartisan support. And every term, I've worked to pass this very simple fix, and I'm really happy that Marshall Hunt is here with me, who has been along on the journey.
Thank you, Senator. The Senator expressed the position on the law quite well. I just want to add a couple things. Bob Doyle, president of the Michigan Association of CPAs, and myself submitted a written statement. I just want to highlight a couple points from that. The issue involves claiming a dependency for a partner in a cohabitation relationship. There are strict federal rules that have to be met. For example, they have to live together the entire year, and that's where the Michigan law comes into play. Federal law says you're not considered to be living together if the relationship violates state law, local law. They have to provide over half support, and the person being claimed cannot make $4,700, has to make less than $4,700 in gross income, which is income subject to tax. So many cohabitating couples cannot claim the other because of the gross income limit. However, I work with several taxpayers, unmarried. The father supports the family, including the wife and the children. The wife is a stay-at-home mother. He can claim the children, but he can't claim the mother, losing a credit for other dependents at the federal level, Michigan exemption, and possibly education credits, and a portion of the home heating credit for lower income individuals. The important thing, though, is that they shouldn't be treated differently than residents of 48 other states. It's important to note that this bill will not change the filing status of the person. All it does is give a dependency exemption, which complies with federal law, for the partner. It will not change their filing status. It will not give them the benefits of marriage, including filing a joint return. So it just is about a dependency exemption. And once the tax preparer determines that all of the other tests are met, then they have to involve with the taxpayer with a discussion on the private nature of their relationship. That's a pretty sensitive issue for the tax preparer as well as the taxpayer. The amounts involved individually might not be large, But for the low-income taxpayers that I work with at Accounting Aid Society, it's a month's rent, it's a month's utility cost, so it's a big deal for them. And there are thousands of individuals involved, perhaps as many as 95,000. A little difficult to get an exact number because of the strict tests related to claiming a dependent. Also, for this change to be effective for 2023 returns, if adopted, I would urge immediate effect. Thank you for your consideration. We're available for any questions, of course.
Thank you both. I was told there would be no math, but it looks like there is some math involved here. And you are saying essentially, I just want to make sure that I have this correctly, this will save taxpayers some money.
It will. Those that qualify, again, they have to meet all of the other tests to claim a dependent, but if they do, then they get the same benefits as people in 48 other states.
Okay. And I know, Senator Chang, you said that this law that's currently on the books has not been enforced. Are you aware of when the last time it may have been enforced?
I have no idea. I have really no idea. I'm hoping that no one's enforcing it. We haven't heard of any stories of folks of it being enforced. This is from 1931, so it's possible that maybe it was early on. I think, but for us, it really is. This is sort of a very good example of a law that clearly does not need to be on our books anymore, and I'm hopeful that we can take care of that.
Okay. Representative Johnson?
Thank you, Madam Chair. I just wanted to know, I realize taxes and money are important, but there's a cultural standard here. And have you looked at also the, it could play into finances, but the statistics on child abuse and problems when there's children in the home. Now, when it's two adults, no children in the home, whatever. But when there's children in the home and cohabitation versus marriage, it's a very different picture. So I'm a little bit concerned about losing a cultural standard and with the safety and protection of children in the home. Have you?
So I guess I would say to that, I mean, I don't know the statistics off the top of my head, but unfortunately, child abuse happens in a lot of homes, whether the parents are married or not. Child abuse is something that we definitely need to address, and we've got lots of bills that we certainly have worked on and can continue working on when it comes to child abuse. But I think that to say that whether or not someone is abusing their children is dependent on their marriage status, I think is not based in at least any of the reality that I am aware of. So I appreciate your thought.
Are there any other questions from the committee? Representative Edwards.
Thank you, Madam Chair. Good morning. Are roommates, non-couples able to qualify as dependents?
Yes, a roommate can qualify as long as they meet the other tests, living together the entire year. The one party has to provide over half support, and the roommate has to make less than $4,700. That's okay. It's when they're doing more than just shaking hands, and then you get into the state law issue of cohabitation.
And just for overall clarification, if this bill is not being enforced or hasn't been enforced in a while, what is the purpose of us repealing it?
I'm sorry,
Why are we repealing it if it hasn't been enforced? What's the overall change, or what's the overall reason for us to repeal this?
Well, I think, obviously we're sort of in a state now where we can try to clear up some of the really antiquated laws that just really don't need to be on our books. So I think that the fact that this is on the books needs to be addressed. Also, I think very clearly there are tax implications. We can save some folks some money, and really just make sure that we're coming into the current century that we're in, and update our laws. But appreciate the question.
I would like to thank one of our listeners in the audience for indicating that it appears the last time this law was enforced was around 1940, and it has not been apparently enforced since. Thank you, Trooper Drosty, for that additional information. Representative Fink.
Thanks, Madam Chair. I guess I have two questions. The first, they're very short, Madam Chair. The first is, do you understand the term lewdly and lasciviously to encompass all cohabitation? Because if not, it seems like a different change could accomplish the goal. In other words, it doesn't seem like anybody wants to promote lewdness and lasciviousness. So is the definition of lewd and lascivious cohabitation, is it the same definition as all cohabitation, I guess is my question. And then secondly, when we say it's going to save taxpayers money, I mean, what's the overall amount of money we're talking about? What's the actual tax implication for Michigan taxpayers?
So on the first question, and I'll let Marshall answer the second. On the first question, so no, it wouldn't apply to anyone cohabitate. If you're an unmarried man and woman living together and you're not being lewd and lascivious, then it wouldn't apply to you. But if you are, then this would. So hopefully that is clear enough, I think.
No, I mean, my question is, like, I take it that it's some form of romantic relationship but is it all of the, if you look at the definition of lewd and lascivious, it's more than just are in, say, a sexual relationship or whatever. I mean, it's the words like offensive and crude and things like that. So is our understanding of this text that it actually when it says lewd and lascivious, it actually means all sexual or romantic relationships? I mean, that's my question.
I mean, that's my interpretation. I think also keeping in mind that this was written in 1931, we're just in a very different time, right? So I think that we, again, need to update this law and make sure that we are, getting basically with the century that we're in. I think that there are just so many, I'm sure, I just remember that when this bill came up in the Senate, I had colleagues come up to me who have talked about how often they, cohabitation is a pretty common thing. And is definitely something that shouldn't be a crime. So that's what we're aiming to address. And on the second question, we'll let Marshall answer that.
Yeah, my best definition is a sexual type relationship, and that's about as far as I can define it. Looking overall is difficult because of all of the requirements to claim somebody, but if you can't claim a dependent that is not related to you, there's different rules for children, grandchildren, but in this situation, what's at stake is up to a $500 federal credit on the 1040, a $5,000 Michigan exemption, which in tax would be about $213, and then possibly education credits that can't be claimed because of the lack of a dependency. And then for the lower income individuals, they could lose a standard home heating credit amount of about $164. So individually, I have the numbers, but you just don't know. There's so many requirements to claim a dependent. I just can't estimate across the board.
Representative Arbit.
Thank you, Chair Breen. I think just to answer Representative Fink's question, I think in 1931, any sexual relationship that was not within the confines of marriage was deemed lewd and lascivious. So I think that would be the definition of lewd and lascivious from 1931. From context clues, that would be what I would gain from that.
Any other questions? Representative Johnson.
Is it limited to one adult dependent? Or once you open this up and they don't have to be married, could it be two? Could it be three? Could it be several adults?
Well, we're looking at the issues what would prevent more than one being claimed would be you have to provide over half their support. So that's one thing. I guess it'd be possible because for example, in the case I'm familiar with that I work with, the father can claim the children, so he can claim more than one dependent, but he can't claim the mother under the current rule. But you have to provide over half support. You have to live with them the entire year, and they can't make $4,700 or more. So I guess it would be possible, because we're not concerned with whether they're married or not. We're concerned with whether they meet the federal test to claim a dependent. So that's the best I can answer.
Representative Devendorf.
Could you claim a pet rabbit or your cats?
My stepson's cat is,
So what you're saying is that there's criteria in there that ensures that only people who actually are dependent will qualify as dependent because they have to meet a strict criteria.
absolutely.
Thank you.
Representative Fink.
Yeah, to just kind of complete this point, say you were an adult and your parents, your elderly parents or whatever lived with you. They could be your dependents, right?
Yes, they can.
Okay, so it's having a couple of adult dependents is not on you. That's not at issue here in your view. The number of people, that's not going to change.
Yes, that's true.
Thank you.
No other questions from the committee? Fantastic. I have some cards here. Trooper Christina Drosty from Michigan State Police supporting the bill, not wishing to speak. Marissa Kovacs from the ACLU of Michigan supporting the bill, not wishing to speak. Stephanie Johnson from the Michigan Health Association of Michigan supporting the bill, not wishing to speak. Thank you, Mr. Hunt and Senator Chang, and we will likely be voting this out of committee next week. I will now like to invite Senator Irwin up here to talk about his bill.
Ready for me?
Yes, sir.
Thank you, Madam Chair, and thank you, members of the committee, for your time today, and thank you for holding off so that Senator Chang and I could complete session and get over here to testify. Look, we know that sexual assault is a big problem in our state. It's particularly a big problem in the campus communities, and I happen to be fortunate to represent some campus communities, and this is an idea that was brought forward to me by some students who said that here is a problem, here's a loophole with the law that makes it harder for us to hold people accountable when they sexually assault someone, and it makes it harder for our prosecutors sometimes to prosecute these people. And the problem that they identified is that currently, what the law says is that you cannot sexually assault someone who is quote unquote mentally incapacitated. That is one of the things in the CSC law that you can't do. And the current law defines mentally incapacitated as a person who is rendered temporarily incapable of appraising or controlling his or her conduct due to the influence of a narcotic, anesthetic, or other substance administered to that person without his or her consent. And what my proposal is to eliminate that part of that sentence that says administered to that person without his or her consent. And the reason why I'm making that proposal is, once again, to close this loophole, to make it easier to hold people accountable when they sexually assault someone, because if someone does not consent, that's sexual assault. And we need to be very, very clear that consent is required for sexual activity in the state of Michigan. And if someone drinks too much alcohol and renders themselves mentally incapacitated, I think our law should reflect that and should deem them mentally incapacitated even if they drank the alcohol themselves. And our law should make it very, very clear that the person who engages in sexual conduct with someone who cannot consent is violating the law. So once again, that's what I'm proposing, is just to eliminate that language that narrowly currently defines mentally incapacitated as something that only happens when someone else does it to you without your knowledge, and just say, look, if someone uses drugs or alcohol themselves and becomes mentally incapacitated, it is sexual assault to engage in sexual activity with someone who is not capable of consenting. So that's the most important point, and I think it'll make it easier for our prosecutors to hold people accountable, and it will take away a creative defense that some perpetrators can try to use when they go into court, and they can say, look, this person doesn't meet this definition, and here's what the law says. So thank you for your time.
Senator Irwin, thank you for bringing this bill up. We've heard some emotional testimony in criminal justice yesterday, and you have touched upon a very serious topic, a loophole that does absolutely need to be addressed. So thank you for bringing this forward. I personally have no questions. I know some people on my committee do. Representative Outman.
Yes, thank you, Madam Chair. Thank you, Senator Irwin, for being here and for bringing this forward. I'm going to apologize in advance. I bring a very ignorant perspective to this committee, but I'm continuing to learn. I just want to be clear. So if somebody consumes alcohol on their own volition, on their own free will, and they're sexually assaulted, they're not prosecuted as of right now?
No, that's not what I'm saying. That could still be prosecuted under current law as a sexual assault, but it couldn't be prosecuted under this section of CSC, and the prosecutor couldn't sustain an argument that this person was mentally incapacitated. And it would allow the defendant to say, well, the defendant or the victim is saying that they weren't able to consent, but right here in the law it says that they're not mentally incapacitated if they did it to themselves and they took these drugs or drank this alcohol themselves. So I want to be very clear that there still is an avenue for prosecution currently. This would just, I think, make it easier, take away that creative defense, and close down this loophole around just this narrow element around mental incapacitation. The rest of the law is still in place.
Got it. Okay. I apologize for my ignorance. Again, thank you for being here, and keep an eye on my dad in the Senate.
Yeah, I'll try, and thank you for the question, because I could have been more clear and just kind of stomping on that ground, because it's an important point.
Thank you, Representative Outman. I also want to thank your willingness to be forward about some of your questions. I really appreciate that, and your willingness to learn and engage. We're all learning a lot, and quite frankly, when it comes to sexual assault, no means no, and that's the bottom line. And this does just make it possible for the prosecutors to proceed under this particular section. We've all heard some terrible stories. Sexual assault is already underreported, and this will hopefully allow victims of sexual assault to not think to themselves, well, it's my fault because I was hammered, or it was my fault because I was high. It's not just because you are drunk, that doesn't mean that you are consenting. And this particular bill does address that component and hopefully will make it easier for some people to come forward. Representative Arbit, no? Representative Fink.
Yeah, I mean, I want to react to a little bit to both the text and Chair Breen's comments just now. Certainly, it's true that just because a person is drunk or otherwise, some other substance or whatever, certainly doesn't mean that there's been consent. In my experience, I was never the lead prosecutor on these cases, but when I was in the Marines, prosecutions for various forms of sexual assault, often involving some kind of intoxicant, very common. And the defense that I think was actually most commonly raised was a sort of mistake of consent, right? Because people often get drunk together and then have some kind of sexual contact, which neither party at the time, or at least the defense is, neither party at the time appears to be saying is non-consensual at the time. So what do you think the result is where you have, say, two drunk people who, as I'm reading this, would both be incapacitated, and they have sex together? I mean, are they now committing a mutual sexual assault?
Look,
this is under this text.
Yeah, this is why I think we have prosecutors and defense attorneys and judges and juries, because every one of these cases is going to be different. And there's all sorts of complexities and all sorts of facts that have to be considered. So it's really impossible for me to say, what would happen in this particular case with a scenario that is lacking that context and all of those facts. What I can say is that there are a lot of encounters that happen where alcohol or other drugs are involved. I don't think this necessarily implicates 100% of those circumstances. This implicates a circumstance where someone is too drunk or too otherwise inebriated to consent, right? So, and someone shouldn't have to scream, no, no, no. A yes is required. Affirmative consent is required, and that's what our law should say.
Okay, I don't see any other questions. I'm also going to take a motion from Representative Edwards to adopt the minutes from the previous meeting. And I will take a motion from Representative Fink to excuse Representative Wozniak. Seeing no other business before this committee, and we will hopefully vote these out next week, we stand adjourned. Thank you.